the liquidation order which is passed by the Honorable, it is directed by the Honorable Supreme Court in the matter of Jet Airways. And we can see that how difficult to implement the resolution plan makes company dragged into the liquidation side. As far as the commercial viability is concerned, that is all that is all identified, or that is all reasoned by the committee of creditors, and it is the judicial mind of the NCLT who gives a sanction to it. But as far as the implementation or difficulty in implementation is concerned, that ultimately that results to a liquidation of the corporate debtor, and it is very well provided also under section 33 of the code. I must say, as far as this IBC is concerned, there are several aspects which are not covered, vis-a-vis the difficulty which are encountered because of the provisions which are not in alignment with the requirement of the code. And I must say, as far as the Companies Act is concerned, because what I feel is once the resolution plan is approved, it is the foremost duty of the RP to intimate the fact about the approval of the resolution plan, to file the copy of the order with the registrar of companies, and leading to that the change of the status gets processed in the MCA portal, and only thereafter the necessary appointment or reporting of the appointment used to take place. But since the code, which is very clear about the provisions pertaining to the approval of the resolution plan, or the requirement to place a resolution plan, or it is the COC who used to commercially judge the viability of the resolution plan, the commercial wisdom is decided by the COC, and after the approval by the COC and after getting a sanction by the NCLT, when the things are not processed due to certain technical aspect, it's a resolution applicant as well as the RP, I must say RA as well as RP, both gets frustrated because of the technical difficulties which they generally face in spite having all the approvals in hand qua the resolution plan. So I must say certain things are not in alignment with the code, and therefore there is certain requirement to be aligned in SEBI LODR, or there are certain requirement to be amended in the Income Tax as well as the Companies Act, so that at least, because see, failure generally happens because of the two reasons. One is the things which are beyond the control of the applicant, and secondly there are certain operational issues which are well within the control of the resolution applicant, and there are certain economic factors which are not within the hands of the resolution applicant after the approval of the plan. So something which is within the control of the government, or something which is within the control of the ministry, I can say that the act should be made aligned with the requirement of the code, so that at least the effectiveness of the resolution plan or resolution plans implementation gets, or it should not get delayed. Because I've seen in many of the cases, even after the approval of the resolution plan, the status of the corporate debtor which was in CIRP is not getting activated in spite of the year. The person whose name are proposed by the resolution applicant in its plan are not being reflected as a director on the ministry's portal. Because it happens, see, once you have allotted the shares, ultimately you need to take care of certain compliances. You may get relief, you may get concession, but pertaining to what you have stated in the plan and nothing beyond that. So that once the resolution plan gets approved, all the necessary compliances which are required under the provision of the Companies Act or any other act, when you try to implement the same, but when there is no proper procedure or the SOP which is prescribed for getting the things done. For example, we used to call, once the CIRP gets initiated, the power of the board of directors gets suspended, and we used to call them SBOD, suspended board of directors. Now, suppose if the resolution plan is proposed by somebody else, not the same promoter, but some other investor who proposed a resolution plan, later on the said plan gets approved and got the necessary approval from the NCLT. But now what happens? When he want to propose its new director on the board, it's always a difficulty on his part to trace that who were the old director, because there is no coordination between the company's old promoter or the old directors and the incoming director. Now, whether to consider them, whether to report the registrar with regards to their removal, or because removal there is a procedure to be followed, it's not even considered as a resignation. You cannot call them a disqualification even, but by the virtue of the court, now their power gets suspended and they will no longer be continued as a director on the board of a corporate debtor which has now been acquired by the resolution applicant. So there is no corresponding change which is required under the Companies Act 2013, which is still made it. Again, this is one aspect I'm sharing. Another aspect I just what I would like to highlight upon. We were looking for, or we have been engaged for one of the assignment wherein the resolution plan was approved by the Honorable NCLT Ahmedabad bench, and the resolution applicant has approached us for just to making certain aspect to be made effective by taking a procedure into consideration. Because in the resolution plan, they have stated that the company's registered office will be situated in Mumbai and not in Ahmedabad. So company, the corporate debtor was in Gujarat, that is in Ahmedabad. Now, to give an effect of that approval of the resolution plan, I am supposed to follow certain process which is prescribed in the Companies Act, so that I can make that resolution plan effective by making the requisite compliance, so that the companies goes within the jurisdiction of the registrar of companies Mumbai. Now what happened is, when we initiated that procedure, now I would like to, this is just an example which I'm sharing with you, just to demonstrate that where the resolution applicant gets frustrated because of the lack of clarity in the corresponding provisions of the company law vis-a-vis IBC. So when we approach the company's resolution applicant, rather I can say, so when we approach the resolution applicant whose plan was approved, we have stated that yes, we want to have, or we need to serve the notice to the creditors. Now they said there is no purpose serving notice to the creditor because the same set of creditor was there in the COC and they have approved the plan. Now it is again the difficulty on my part is to convince the registrar or to convince the regional director that why we have not served notice to the creditor. Now to make them understood that this resolution plan was itself proposed by the committee of creditors and they are the creditors who are right now on the books of the corporate debtor. Because basically when we see a company's creditors, so they are the creditors of the corporate debtor, and the corporate debtor is now being acquired by the resolution applicant. There is no other creditors. Now, the same creditor, the same set of creditors, those who have approved the resolution plan, now the other law, the Companies Act, mandates me to serve notice to them. Now, serving notice to them, waiting for their objection, if any, and then again to move it before the regional director that we have not received any objection. And many times I've seen that during the state procedure, the registrar of companies or the regional director, they used to bring certain facts on record that these are the overdue compliances leading to which we will not be in a position to allow you or permit you to shift your registered office. Now, that is something which very well get covered in the relief and concession. But now the question is, what in case if those relief and concessions are not allowed or not permitted? It happens. One more thing I would like to say. So, a lot of difficulties which the resolution applicant face for the removal of the name of the erstwhile director of the corporate debtor who are no longer going to be considered as a director on the board of the corporate debtor after the approval of the resolution plan. But this is what I said, that you may not treat this as removal. You cannot even treat this as a resignation. You cannot treat this as a disqualification. You cannot treat this as, you can say, a vacation on any other ground. So basically, there is an alignment which is required, which is not there. So this is one of the difficulty which I face, or which we generally face. Now, this is, I'm talking about a very pure technical aspects. Getting the status of the corporate debtor changed from under CIRP to active is another challenging job, and we will be discussing with the circular also, which has been brought in by the Ministry of Corporate Affairs, because now this power has been taken
Excuse me, sir.
away. Yes, sir.
Yeah, actually, these kind of suspended board of directors, when they are not able to pay the debt, can't they be straight away be taken as a willful defaulter and classified them as
See, I'm talking about, see, as far as my concern
once
right
he is
now.
declared as willful defaulter, he will
No,
not
no,
be
see,
qualified for.
but sir, this is a case wherein they are classified as a willful defaulter, but there is no provision under the Companies Act which mark them disqualified on the grounds of willful defaulter. My point is very much confined to, I'm just
So
picking.
that alignment is missing. Yeah, that alignment is missing.
Absolutely. So my starting point of discussion is pertaining to an example which I'm facing day in day out. Now, so I being a company secretary, people always expect that you being you can say a practicing lawyer appearing before the NCLT, understanding the crux of the resolution plan, its timely implementation, so you can very well represent us before the registrar office also. So when we approach the registrar with this set of proposal, that this resolution plan includes the provision of extinguishment of shares, they always come up with whether you have complied with the provision of section 66 of the Companies Act, which talks about reduction of share capital. Now it is not possible for me to comply with the provision of section 66 of the Companies Act when my plan has got a blanket approval from the tribunal, and before that it was the COC who have commercially approved my, or with their commercial wisdom my plan gets approved. So it happens. To give them exit as a challenge, to bring my new directors on the board as a challenge, to get the status changed from under CIRP to active as a challenge. The challenge is only because of the alignment or the corresponding changes in the Companies Act is not brought in by the ministry, and leading to this failure or leading to this delay, I can say at this moment, there are certain things which are very ambiguous in nature. Every registrar of companies are having own set of SOPs, and that's why this issues are immediately required to be addressed upon. That is one aspect. Second aspect, which I would like to cover up in today's session, with regards to both the judgments, that is Jet Airways as well as ABEX Singapore, because in both this issue, the concern was pertaining to some modifications in the plan. In this particular case of Jet Airways, after seeking an extension by extension, when they failed to bring in or pump in the resolution amount which was decided, and later on NCLAD has said that the amount which is there is a performance guarantee which is right now brought in, or which was brought in by the resolution applicant of the Jet Airways, can be utilized or can be treated as the amount brought in by the applicant. Now, that is something which I would like to say. Now, there is an operational difficulties, and to mitigate such operational difficulties, it is very important that resolution plan should be prepared in a manner as if there should not be any there should not be any condition precedent. Because when a plan is backed by, or when a plan is contingent in nature or conditional in nature, its implementation is depending upon happening or non happening of certain events, and ultimately that delay or to get the fulfillment of that condition precedent itself impact, and it impacts, it badly impacts the ultimate valuation of the asset of the corporate debtor acquired by the resolution applicant. And later on, when such companies goes into liquidation, ultimately it impacts the stakeholders interest and the economic interest in a very prejudicial manner. So I must say that as far as the discussion in today's session is concerned, I would like to keep the agendas in a manner. Firstly, we will be dealing into the aspect which are covered within the law. So we will be dealing into the aspect of section 30, we will be dealing into the aspect of section 31, section 33, and we cannot ignore the provisions of the law when we are going to detailing about, or when we are going to discuss about the intent brought in by the Supreme Court in its judgment of 7th November 2024 with regards to Jet Airways. So it is very important that we should see what is within the ambit of the code, and in line of that particular ambit, or in line of that particular jurisdiction, the Supreme Court has decided that why this Jet Airways should be liquidated, and why the liquidation per se will bring a resolution and not the resolution plan. So that is one abex we are going to take care of, that whether any modification or withdrawal is possible or not. Right now, the air is very clean and there is no such kind of approval which can be sought before the NCLT without approaching the COC. And COC generally will only permit the resolution applicant if there was a provisions in the plan, but the plan may contain a provision of modification but cannot contain a provision of withdrawal in certain circumstances. So first we are going to deal with the provisions of the law, and we are going to deal into the aspect of the regulations also. So the code with regulation will be the first aspect to be taken care of. The discussion paper, which is an outcome of the Supreme Court judgment with regards to Jet Airways, we are going to check on that part, wherein the utmost importance or weightage is given to a mandatory clause to be inserted in the resolution plan for constitution of the monitoring committee, which is generally decided nowadays by the COC while approving a resolution plan. So we will be dealing into that aspect of the monitoring committee and its role there after the approval of the resolution plan to oversee the implementation. We will be taking care of a circular, a general circular of the Ministry of Corporate Affairs, which talks about the duty which the IRP or RP will be having after the admission of the corporate debtor into CIRP, and the compliances which the liquidator, or the compliance which the RP has to take care of after selling a corporate debtor as a going concern, or after getting an order of dissolution from the NCLT, or after getting an approval of the resolution plan or the order thereof from the NCLT. So that general circular is also going to be somewhere important. And later half of this discussion will be revolving around what happened in Jet Airways and the ABEX Singapore case. So this will be the agendas. This will be the modus which we are going to follow as far as today's session is concerned. But before we start, I just wanted to have your views in the subject, because you are the practicing insolvency professionals who either must be dealing into the CIRP liquidation, or else you must be rendering the support services to the IRPs and RP who are handling the CIRP and the liquidation cases. So what, according to your, where you have faced the practical difficulties while assisting or while handling the assignment of the CIRP or the liquidation or the post approval of the resolution plan? I would like to have your views, so that at least certain things which are required to be deliberated and discussed upon, other than what I have decided for today's agenda, can also be taken into consideration. I have your views, please. I
Hi,
will
good
appreciate in
morning.
case. Yes, sir.
I am Rajesh Tukral, practicing advocate, not an IB. So, in one of my cases, what happened? The resolution applicant who has given a resolution plan,
Hmm.
the implementation period is just 3 months. The plan is pending for more than 5 years now. It was filed in 2020. And now the resolution applicant is taken into custody by Enforcement Directorate for some other frauds, which alleged frauds, which he might have committed somewhere else in obtaining finances, etc. Now that person is in custody. 29A per se does not specifically debar a person who is not convicted from being a resolution applicant. But given that the ED has attached his all the assets and the person in the custody, the implementation is doubtful. So that's a big issue that has just come up. So how to deal with that situation? And the matter cannot be remanded back to COC. So what should be done, and what would be the legal rights of the SRA in such circumstances?
Now, this is something which is very important, and I was about to touch upon this subject, not exactly on the same grounds, but yes, I've seen in many of the cases once the resolution plan gets approved, that means once the resolution plan gets approval from all the necessary authorities also, so has got the consent from the COC, has got the mandate from, has got the note from NCLT also, and thereafter from the other authorities, for the sake of implementation, I've seen many of the people are also interested to acquire such entities, to step on, to step in the shoes of the resolution applicant. And I've seen the resolution applicant in fact are more willing to come out of the implementation obligation with an intent to dispose of the obligations by handling over the rights and duties. Now this is something which is not falling within the bracket of the code, and I have not seen any COC giving a note to such a plan wherein such a flexibility which is standard by the, when I must say the guardian is willing to hand over the corporate debtor to some other guardian. So this is something which I must say that in this circumstances, when it is practically not possible for the same person who was the successful resolution applicant to implement the same, there has to be some provision, or there has to be some role which should be given, or there should be some power which should be given to the monitoring committee or to the monitoring agency to decide upon, to dealt upon such aspect in a similar state, or
So,
in a very
so
similar setting.
one correction in this matter, the plan is approved by the COC, but it is yet to be approved by the adjudicating authority.
Again, the withdrawal is not possible considering ABEC Singapore.
Absolutely.
So it happens, and in that case it's only the COC who can be a, you can say, can be a savior in the circumstances, because COC has to understand that it is now not being implemented, because we know that judicial custody, or we never know that how long that litigation will proceed and how that litigation is going to impact the corporate debtor which has already been troubled through a process and now been taken over.
Absolutely.
Fresh EOI can be an option available. It is the COC who can now commercially think upon the ultimate, you can say, what ultimate the outcome of this particular contingency. So I must say, in this
But can
circumstances,
COC withdraw this plan on its own?
see, COC can
Because the
take
law
up
is
this
not
particular,
permitting.
see, as far as the withdrawal is concerned, it's always when you go for an withdrawal, the heat of the COC generally which you need to face. But when the COC per se, or when the COC itself are of that opinion that why the modification should be allowed, or why the replacement of the resolution applicant should be allowed, or why the liquidation can be more viable option for them to get the maximum proceeds out of the corporate debtor asset, in that circumstances I don't find any challenges when these things are getting the necessary deliberations first get clear at the COC level, and then the same is being placed before the adjudicating.
I think there is some problem with the signal.
Sorry, I lost the connection because of some frequent power cut at the side, but I hope I'm audible now. And
Yes, yes, audible.
so yes, we was on the point. We were on the point that generally such withdrawal or modifications in the plan gets opposed by the COC. But in this given case, wherein the COC is the right now authority who can decide upon that what next when a resolution applicant is not in a position, or right now the circumstances will not permit them to implement the plan or to honor the plan. In that circumstances, it is still well within falling within the commercial wisdom of the COC to decide upon the case that whether to permit withdrawal, whether to permit modification, whether to drag the corporate debtor into liquidation, whether to come up with the revised EOI. So that is what I must say at this moment, that COC is well within its power at this moment when the implementation is not seemingly possible or it is not viable. So, for the interest of the COC and for the interest of the corporate debtor as a whole, they can very well permit such withdrawal, or they can very well permit such modification in the resolution applicant, or they can even decide upon the liquidation of the corporate debtor in the given case.
Right.
Some other views from the other participants, from the other insolvency professionals, because we have the judgments with us which is decided upon, but there are certain matters which are within your hands which are yet to be decided upon, but probably that may be a next matter before the NCLAT, or that can be a next matter before the Honorable Supreme Court. So I must say at this moment I will appreciate your inputs on the practical difficulties which are being faced.
Sir, what is the duty of the RP once the institute is, the corporate debtor is transferred to the resolution applicant,
And that
resolution
is very
manager,
well, yes sir, and that is very
and
well
the corporate
highlighted by the,
and
yes.
the suspended board of directors are not coming forward to transfer the assets or the CD to the resolution applicant. Whose
No, no sir,
duty is
this
that to,
this
whether,
is very, I must say this stage comes at a very later on, you can say, phase. The reason is once company goes into CIRP,
yeah,
it's always an IRP who need to step out to take the custody of the asset, right?
okay,
At this moment the question pertaining to that resolution plan which has been approved, at
yes,
this stage when you say that the corporate debtor or the suspended management are not leaving out the custody or freezing out the custody, it never happens. Section 19 is there for this particular cases only,
yeah,
wherein in case
actually
if you are
yesterday
not getting, yeah,
yeah,
so in
yesterday,
this given circumstance I have never seen any case wherein in spite of being the resolution plan been approved by the COC and the adjudicating authority, the concern is pertaining to the asset which are well within the custody of the SBOD. It never happens, sir.
sir, 1 minute, sir. Yesterday, I overheard one case that is happening at NCLT, where
Hmm.
the sitting member was saying that it is not the responsibility of the resolution professional to file a case as regard to seeking cooperation for transferring the assets and all that. It is the resolution applicant who has to approach the court.
Absolutely. So, after the approval of the resolution plan by the adjudicating authority, now in that circumstances, you cannot expect now RP to take a call or to move an application before the adjudicating authority for the issues connected with this particular case. So, it is always the RA who need to stood up, or it is the RA who need to take an appropriate action to get the custody of the company's asset for which his plan get approved by the COC and by the adjudicating authority. It is very rare possibility. The reason is before RA come into picture, it is always the IRP, RP, or the liquidator who must have taken the custody or who is bound to take the custody of the asset of the corporate debtor. In that given circumstances, if the RP or the IRP has not acted upon, probably the issue is being faced by the ultimate resolution applicant, the successful resolution applicant. So in given circumstances, it is always a onus on the part of the resolution applicant, or it is always a obligation. I can say that being a person in within the monitoring committee, it is the RP who is surely going to assess the case or is going to represent the case, but ultimately this action is going to be initiated by the RA and not the RP. It's now functions of issue. Apart from that, any other incidents which you have seen or which you are facing or which you have faced and decided upon, wherein in fact a resolution plan was approved long back but till date not been implemented? Because this is what I say, that post approval of the resolution plan, it's non implementation. The code is not going to govern certain things. Code is very clear as far as section 33 is concerned, that if it has not been implemented, then creditor can very well move before the adjudicating authority for seeking an order of the liquidation. Or if the plan which is approved by the adjudicating authority is not been implemented or is violated by the successful resolution applicant, it is very well falling within the jurisdiction of the NCLT, the same adjudicating authority, to change the ultimately what we call the ultimate obligation of the resolution applicant. Suppose if he failed to perform, then in that case fortune and future of the corporate debtor is falling, is well goes within the hands of the adjudicating authority, and adjudicating authority may pass an order for the liquidation. When jet goes into the liquidation, any other entity may face the same may face the same heat, may face the same consequences.
When this resolution plan is to be implemented and is not getting implemented for various reasons, can the lenders simultaneously initiate actions under SARFAESI against their security after
See,
this
ultimately,
escalation?
what happened, the lender's right during the course of moratorium was freezed.
Yeah. Now its
Correct.
moratorium is
So, no,
lifted.
no, I'm coming to your question ultimately.
Okay.
When the application was admitted, their power to initiate an action was freezed because of Section 14.
Yeah.
But they have all their right to file their claims, which they have filed before the before the resolution professional or the interim resolution professional. And that was considered or partly considered or rejected by
Yeah.
the RP. And the
Mm.
same is, or the same was covered as an aspect to be taken care of while admitting the resolution plan. Now, in that circumstances, now in the resolution plan, if they have accepted certain amount or they have accepted whatever the haircut was proposed by the RA that was approved by the COC. Now, suppose if it is not being implemented,
Yeah.
suppose that is not being implemented, your question is about non-implementation of
It's not
was
going
the
as per
proposal
schedule.
within
Mm.
the plan. So RA, the successful resolution applicant, failed to honor its obligation. It is again falling very well within their rights to initiate an action. There is no bar that they are not allowed or they will not be permitted, because if the resolution applicant is of that opinion that you cannot take this action under this particular law because of this approved resolution plan, the counter to that issue would be that what about the obligation which you have promised and which you have committed or which you have confirmed to comply? And that's why this is what I said, the same creditor can very well take an action as you said under that surface, and as I say, they can very well think upon and they can very well act upon their own application for liquidating the same corporate debtor.
And the other issue that is when lenders are preferring SARFAESI or other actions than IBC because it is very costly and their enforcement rights are being sacrificed.
This absolutely, because now this answer can be very well given by the learned RPs who are handling multiple cases day in, day out, or at least month in, month out, or year in, year out. So, yes, we have seen this from the trend itself. This can be very well identified from the cause list nowadays, that the lenders have started preferring the SARFAESI over the IBC.
Correct.
Majority of the matters nowadays are relating to whatever haircut they have accepted. The matters are now only pertaining to the personal guarantor and not of section 7 or section 9 to that extent which was there a few years back. So if you have anything beyond what has been discussed, we can very well touch upon those aspects. Other than that, we can reach out to the code, we can reach out to the regulation, and we can reach out to certain judicial precedents. I'm sharing screen. The first, and this is what I said, that the agenda shall confine to the code and regulation will be touched upon initially. After taking care of the code, the governing provisions of our today's topic, we will be taking care of both this aspect as far as the what had happened in this Jet Airways case or ABIC Singapore case and other judicial matters wherein the question was pertaining to the withdrawal, or the question was pertaining to modification, or question was pertaining to non-implementation, or question was pertaining to the condition precedent in the resolution plan. Is this visible?
It's visible.
Now, this is the provision of Section 30, and which I feel is relevant to touch upon before we proceed further with the subject or with this point of discussion today. Now, as far as Section 30 is concerned, it is coming well within the knowledge of all the participants, basically, considering the fact that this is the step, or rather calling it as the first step when we talk about the non-implementation. It is always resolution applicant submit resolution along with the affidavit is that the approval, and it is difficult for one to identify that who is the face behind the successful resolution applicant, or who is the motive behind a successful resolution applicant, who is the force behind the successful resolution applicant, or where actually the money is coming from. The one who is proposing a resolution plan, I've seen they are just the face to demonstrate before the adjudicating authority, and the ultimate implementation depending upon the one who proposed or who prompted that resolution applicant to be a proposed resolution applicant. I've seen this, that when company or when the RP comes up with form G for inviting expression of interest, you find lot of EOI being submitted. The one who is behind that curtail, or one who is behind the curtain, or one who is behind the door, who is not himself eligible to propose a resolution plan because of 29A restriction, are proposing few of their entities name, are proposing few of their own individual name, who otherwise are eligible under 29A but does not hold any control over the plan or its implementation. These are one of the generic reason of the non-implementation or failure of honoring the terms of the resolution plan, and there is no control, or there is no governance over the same, because I as an IRP or I as an RP is only going to cover up and touch upon those aspects which are before me. So I'm going to have a due diligence from, or I'm going to due diligence of that person, or I will undertake the due diligence of that plan, and I will undertake the due diligence of that resolution applicant, the prospective resolution applicant. But I will not look after that who is, or what is the motive behind, or who are the person behind that curtails. The resolution professional shall examine each plan received by him to confirm that now this is something subsection 2, which we are very well aware of. Now this is something which falls within the ultimate judicial review, what we call by the adjudicating authority, that fees for payment of CIRP cost in a manner as may be specified by board in a priority over the other. This is something which we are aware. Provide for the payment of the debt of the OC in a manner as may be specified by the board, which shall not be less than the amount to be paid to such creditor in the event of liquidation of the CD, or the amount that have been paid to such creditor if amount to be distributed under the plan have been distributed in accordance with 53. I'm not going to touch upon this subject because right now we are very much confined to the difficulties in implementation or consequences of non-implementation, whichever is higher, and provides for payment of debt of the financial creditor. So that is a dissenting financial creditor in a manner as be specified by board, which shall not be less than the amount to be paid to such creditor in accordance with subsection 1 of 53 in the liquidation of the corporate debtor. So this is something which we are aware of. I'm not touching on the aspects which are not relevant for today's session, but yes, will be touching. Yes, I am also not so much convinced with subsection 5 that resolution applicant may attend the meeting of the COC in which the resolution plan for the applicant is considered, provided that the resolution applicant shall not have a right to vote at the meeting of the COC unless the resolution applicant is also a financial creditor, meaning thereby many of the aspect is also depending upon subsection 5, and I just would like to have my views on it. See, if I'm a resolution applicant proposing a resolution plan and I'm also a member of the COC, much of the things are within my control. So if I, being a resolution applicant as well as a member of the COC, hold a percentage of the voting share which is enough for the approval of my plan or which is enough for the rejection of the plan proposed by my counterpart, the very important point. In companies at what we study is interested director will not be allowed to participate or vote. They are not even counted as a quorum. In Companies Act, we also have a provision under 188 of the Companies Act which talks about a related party transaction. And if I am the one who is the related party, or if I am the one who is concerned or interested, my voting right for that particular business item or my voting right for that particular agenda in which I'm interested should not be allowed or should be barred. But unlike the Companies Act subsection 5, very important this is, which do have a far-reaching impact on the non-implementation. The resolution applicant may attend the meeting of the COC in which the plan of the applicant is considered. Okay. Up till this extent is okay. Applicant shall not have a right to vote at the meeting of the COC unless the applicant is also a financial creditor. So taking otherwise, if a resolution applicant is a financial creditor, then he will be having a right to vote. And when a resolution applicant is voting for its own plan, you cannot call that decision is taken as per the commercial wisdom of the applicant. It's always the personal wishes are going to flow with his resolution. So in every circumstances, he is going to give the first vote and he will give a priority vote to its own plan. So one who is proposing a plan is also being considered for that meeting and is also being allowed to vote for his own plan. And tomorrow, if the same plan gets failed, or if the plan is not in a position to get implemented, then in that circumstances, where is the commercial wisdom of the COC? Or where is about, or what is the viability of such plan which is being sanctioned by, or which has been approved by, or which has been proposed by the same person who is right now facing difficulty in its implementation? I just wanted to have your views on subsection 5. I wanted to have your views on subsection 5. I don't know for what reason till date the validity of subsection 5 is not being challenged, but I feel this is one of the very important subsection to be addressed upon by the government. Subsection 5 of section 30. Your say, I will appreciate your say on this.
No, it is just to give an opportunity to to settle the things very amicably.
Sir, my point is, You are proposing a plan
Yeah.
holding voting percentage, say 35% voting shares,
Okay.
which is sufficient to be a roadblocker for any other prospective resolution applicant like me.
Okay.
The only difference between we two resolution applicants are you being a member of the COC, I'm not a member of the COC. Subsection 5 is very clear that we both are allowed to have our seat on the, we both are having allowed to have our seat in that COC meeting wherein our plan is going to be considered
Discussed.
or discussed or deliberated upon or voting upon. But my point is the aids, the benefit which you are having over me, the advantage edge which you are having because you being a member of the COC and I'm only a resolution applicant, you are going to review upon, decide upon your own plan. And as I said, the voting percentage which are available with you are sufficient to block my plan or are sufficient wherein your approval will lead to the approval of your own plan. Your voting will lead to approval of your own plan. So
Even though
you are
your plan is better than mine.
absolutely. So we are calling your decision as a commercial wisdom.
But ultimately has to go to adjudicating authority for whether
No, but
they will
adjudicating
look at it
authority
whether
are not, adjudicating authority will not sit over the commercial wisdom of the COC. I just
in
wanted to
this.
have the views from all the participants, I must say, because I always believe that whosoever is joining the session is somewhere joining because of the problem which they are facing, or the problem which they have faced and they came out of it, or they are under process to resolve the ongoing problem. And I believe that subsection 5 which I'm sharing with you, I have never faced any relevance of giving that applicant an edge over the other applicant if he is a member of the COC. How a person placing his own plan get the right to vote over his own plan? My question is very limited to this because this maybe, I'm not talking about that this is a fundamental or this is a primary reason of the failure of implementation, but this may be a reason of the failed implementation.
There, I think the financial creator will also have a right to vote. That should be
No,
that they should not have. No,
every
actually,
financial
when his resolution plan is considered for, giving that voting right of that fellow should not be there.
what does the others say?
And this is clearly a conflict of this thing, maybe.
That is what my point is.
Not
That's
only
a very,
conflict of
very
interest,
interesting question.
that will also be not in the best interest of all the creditors or that
Absolutely,
city
sir.
itself. City itself.
Because, sir, when a person is proposing his own plan, sitting over the commercial wisdom of his own plan, thinking about its viability, its commercial viability, its implementation. So he is proposing a plan and he is voting over his own plan. How he is going to measure his plan is always going to measure in a positive sense. And tomorrow, when the same person is failing to implement the plan, why the voting rights are still being permitted in spite of being the most related party?
Related party of financial creator.
Yeah, on the one
So
hand,
a
we are not
creditor,
allowing the board of directors to participate or vote in the thing, and on the other hand, we allow the COC to vote on
It
his
is
own. That is,
absolutely because the law is very settled as far as the Companies Act is concerned. If any of the agenda in which I'm interested, whether financially or otherwise, or any of my relative, because of any of my relatives, so not directly but indirectly, I am bound to give a disclosure of the fact, and after giving a disclosure of the fact, I should not be allowed to be counted as a quorum for that meeting, for that agenda itself, and
Yeah.
I should not be allowed to vote. So, why the same rationale is not being taken care of while considering the resolution plan of the member of the COC who is very much interested in his own plan? So, that is what my thought process is, or that is what I have decided to deliberate upon the aspect, because being a learned member, you always have your own views. But at this moment, I have not seen any challenges are being made before the Honorable Apex Court in this regard.
Uh, Whether any
The
such
challenge
cases
would
were
be
there
made
in the
only by a
past.
person who is aggrieved. Now the
Absolutely.
question is, who would be aggrieved against the resolution applicant?
So aggrieved would be his counterpart, the other person who is the prospective resolution applicant,
No,
and other.
prospective.
He can challenge,
Absolutely.
He can challenge.
So this
So
is one
suppose,
aspect. Other thing. Now this is very important. Section 31. Section 31 of the Insolvency and Bankruptcy Code states that if the adjudicating authority is satisfied that the plan is approved by the COC under subsection 4 of 30 meets the requirement as referred to in subsection 2 of section 30. So this is the only aspect which the adjudicating authority is going to review upon, is going to, you can say, take into consideration. Adjudicating authority, if it is satisfied that the plan is approved by the COC under 4 of section 30, meets the requirement as referred to in subsection 2 of section 30, that what the operational creditor should at least get, what a descending financial creditor should at least get, whether the CIRP cost in full is covered in the plan or not. This is all the aspect under subsection 2, which is not a point of discussion for this session. But this is what I would like to say, that the jurisdiction is confined to subsection 2, the judicial review. It shall by an order approve the plan, which shall be binding on the CD, its employees, members, creditors, including government, state government, central government, local authorities, to whom a debt in respect of the payment of due arising under any law for the timing force, such as the authority to whom the statutory dues are owed, guarantors, and other stakeholder involved in the plan. So this is giving a binding effect, that if the adjudicating authority is satisfied that the plan is approved by the COC under subsection 4 of section 30 is fulfilling the requirement as referred to in subsection 2 of section 30, it shall by an order approve the order. It's very clearly stated, it shall by an order approve the plan, which shall be binding on the CD, its employees, members, creditors, government, local authorities, guarantors, other stakeholder involved in the plan. Adjudicating authority shall, before approving or before passing an order for approval of the plan, satisfied that the plan has a provision of its effective implementation. Now, this is something which I would like to highlight upon, that adjudicating authority, before passing an order for its approval, satisfied that the plan has a provision for its effective implementation. What is the meaning of the said proviso, satisfied that the plan has a provision for its effective implementation? Meaning thereby, all those aspects are required to be taken care of, which are deliberated upon this initial discussion, the ongoing litigation because of which the person is in the judicial custody. Dr. Saab, you have raised this concern that in your case, the resolution applicant, see, in that particular case, the plan has not received the approval from the adjudicating authority. COC has already approved that resolution plan. Now, in that case, if something is applicant, he has to give a disclosure. Doesn't matter whether it is falling within the purview of 29A, so that COC with open mind can decide upon the fact, can oversee the contingency which are falling from that plan.
Yeah, we are
Your
working
views
on
on
this
this
only, actually.
Yes, sir.
We are working on this only because this
Because
case is still
this,
pending.
yes,
So
sir,
we are working on this only.
this first proviso is very relevant, and
Yes.
how one adjudicating authority's role extended before passing an order for the approval of the plan under this section. Adjudicating authority has to satisfy that the plan has a provision for its effective implementation, and that extend the role that extend the scope, that extend the power of the adjudicating authority. This is what I believe.
Right.
Considering the case which are coming before the adjudicating authority now and then, we have seen in Jet Airways, in the plan itself, there was a condition precedent कि ये पैसा तब आएगा जब ये लाइसेंस मिलेगा, जब ये अप्रूवल मिलेगा. And there is always a possibility that condition precedent may not be fulfilled. Then what, you are going to withdraw the plan, putting the stakeholders' interest in limbo. I will invite your views, sir. And I believe that this only subsection has widened the scope of the adjudicating authority beyond section 30, subsection 2. Adjudicating authority, before passing an order for the approval of plan, satisfy that the plan has a provision of its effective implementation. Now, plan having a provision of effective implementation, because what I believe, if there is a condition precedent, then there has to be certain clauses in the plan that what in case if this condition is not going to be fulfilled, will there be any other thought, or will there be any other way out to give a life to the plan, or to honor the obligation which are proposed in the plan? Your views are welcome, sir. Any other participants have any thought on this? So this is one. Another thing is, the adjudicating authority is satisfied that the plan does not conform to the requirement of subsection 1 by an order reject the plan. So if it is not in compliance with subsection 2 of section 30, or if the plan do not have any provision for its effective implementation, and here I would like to say the role of monitoring committee comes into picture. That how, because the people who are in the monitoring committee thereafter are the one who are right now the member of the COC, how they look into it. And this deliberation is very important, that the provision for the effective implementation, all the contingencies which are surrounding thereof. After the order of approval under subsection 1, the moratorium order passed by the adjudicating authority under section 14 of the code shall cease to have effect. The resolution professional shall forward all records relating to conduct of CIRP and the resolution plan to the board to be recorded on its database. Now, subsection 4 is very important. Subsection 4 of section 31 states that the resolution applicant shall, pursuant to the plan approved under subsection 1, obtain the necessary approval required under any law for the timing in force. And this is what was the condition precedent in JED matters. The applicant, pursuant to the plan approved under subsection 1, shall obtain the approval required under any law for the time in force within a period of 1 year from the date of approval of the plan by adjudicating authority under subsection 1, or within such period as provided for in such law, whichever is later. So suppose if any other law, for example, Competition Commission of India, because of the combination, you are supposed to take an approval from the competition CCI. So suppose if that act permits you to get an approval within any extended time beyond 1 year, that will prevail. So word which is used in this subsection 4 is later and not the earlier. Subsection 4, I would like to read it again. The applicant shall, pursuant to the resolution plan approved under subsection 1, shall obtain the approval required under any law for the timing in force within a period of 1 year from the date of approval of the plan by the adjudicating authority under subsection 1, or within such period as may be provided for in such law, whichever is later. And this is what provided that where the plan contains a provision for combination as referred to in subsection 5 of the Competition Act 2002, the applicant shall obtain the approval of the CCI under the Act prior to approval of such plan by the Committee of Creditor. Now, see, This is very well covered within the provision of the IBC itself, that no post approval. There is nothing a provision of a post facto approval. Here it is provided that you need to take the prior approval before getting the plan approved by from the COC. The CCI have kept, or CCI have taken care of this particular part in a very cautious manner, and this is well framing within the part of the code or falling within the ambit of the code itself, that no approval of the committee of the creditor shall be granted when the resolution plan contains a provision of combination as referred in subsection 5 of the Competition Act. The applicant shall first obtain the approval of the CCI under that act, that is Competition Act 2002, prior to the approval of the plan by the committee. This is something which is very clear, so that this ambiguity should not survive, that even after the approval by the adjudicating authority, the plan is not getting the necessary mandate, or the necessary approval of the CCI is not being extended. I'm not going to touch upon the appeal, but this is something which is very, very relevant. 32A. But before we dealt with 32A, let's see 33, because it is having our relevance with our topic. Subsection 3 of 33. And this is what we have seen in Z, where the resolution plan approved by the adjudicating authority under section 31 is contravened by the concerned corporate debtor, any person other than the corporate debtor whose interests are prejudicially affected by such contravention. Person other than a corporate debtor, meaning thereby a corporate debtor itself cannot go for a liquidation. Any person other than a CD whose interests are prejudicially affected by such contravention may make an application to the adjudicating authority for a liquidation order as referred to in subsection subclause 1, 2, 3 of clause B of subsection 1 of section 33. Very relevant. So the lender or the other stakeholder whose interests are adversely impacted because of the non-implementation of the plan or the contravention of the plan, then in that circumstances, they can very well move under section 33 before the adjudicating authority for seeking an order of liquidation. This is 3 of section 33. Section 33 is the power of the adjudicating authority to pass an order of liquidation. But in case where the plan was already approved under section 31, the plan approved by the NCLT, co-adjudicating authority, under section 31, if it is contravened by the concerned corporate debtor, any person other than the corporate debtor whose interests are prejudicially by such contravention, affected by such contravention, may make an application to adjudicating authority for liquidation. And on receipt of the application under 3, if adjudicating authority determines that the CD has contravened the provision of the plan, and this is what happened in Jet Airways, the amount which was placed or given as a performance guarantee, you cannot utilize that amount as a resolution amount, right? Because it is provided that will stand forfeited in case if the plan has not been implemented. On receipt of the application under subsection 3, if the adjudicating authority determines that the CD has contravened the provision of the plan, it shall pass an order of liquidation under clause 1, 2, 3 of clause B of subsection 1. Yes, your views on the same. Mr. Rao has raised this concern, non-implementation of the plan by the successful resolution applicant, an action intended to be initiated by the secured creditor under SARFASI. So this is the alternative remedy which is available if your creditor is not secured one, and SARFASI is not the remedy available to him. The other participants, I will appreciate in case if you can raise certain queries, or if you can raise your concern, or if you can raise certain points for deliberation. Otherwise, this code is something which is known to both of us. And it's always important that you can bring out certain thing out of the provision, so that that would be a healthy discussion for the next 1.5 hours. Going back to section 32A. Section 32A has again made certain things very clear, and that was brought in with effect from 28th of December 2019. Section 32A. Notwithstanding anything to the contrary contained in this code or any other law for the timing in force. Now, this is talking about the liability, and liability pertaining to the corporate debtor, not pertaining to the erstwhile promoter or the criminal proceedings against the erstwhile promoter. The liability of the corporate debtor, and this is the charm of the IBC, section 32A. The liability of the corporate debtor for an offense committed prior to the commencement of the CIRP shall cease, and the corporate debtor shall not be prosecuted for such an offense from the date the resolution plan has been approved by the adjudicating authority. Under 31, if the plan results in change in the management or control of the CD to a person who was not, so meaning thereby subclause A और subclause B में जो दे रखा है उनके हाथ में ये कंपनी नहीं आती है तो ही ये privilege मिलेगा. And I would like to say this is the heart of the code, or this is the charm of proposing a resolution plan for a distressed corporate debtor. Notwithstanding anything to the contrary contained in this code, so this will prevail, or under any other law for the timing in force, the liability of the CD for an offense committed prior to the commencement of the CIRP shall cease. And you cannot expect registrar of companies to say that this is not complied and that's why you will be liable to make this much penalty, or you are liable to be prosecuted for this particular offense which is prior to the resolution plan. Now, it is having nothing to do with any relief or concession, whether prayed for or not. It has nothing to do with any relief or concession being prayed for or not, because it is 32A. The liability of the CD for an offense committed prior to the commencement of the CIRP shall cease. CD shall not be prosecuted for such an offense from the date of the plan has been approved by the adjudicating authority. If the plan results in the change in the management or control of the CD to a person who was not a promoter or in the management or the control of the corporate debtor or related party. So meaning thereby the company should not come within the hands of the promoter or in the management or control of the CD or its related party. In that case, what you have stated in the plan and what has been approved by the COC will be important then. If a person with regards to whom the relevant investigating authority has on the basis of material in its possession has reason to believe that he had abated or conspired for commission of the offense, or has submitted or filed a report or a complaint to the relevant authority or the court. Repeating again, if the plan results in change in the management or control of the CD to a person who was not, so meaning thereby the company if coming within the hands of the same SBOD, then you cannot take the privilege unless provided otherwise in the plan and approved by the COC. A promoter or in the management or the control of the CD or related party of such person, promoter or a person in management or control of the CD or related party of such person, or a person with regards to whom the investigating authority has on the basis of material in its possession reasons to believe that he had abated or conspired for commission of the offense and has submitted or filed a report or a complaint to the authority or the court. So again, the question which was raised by Mr. Rao, or sorry, the question which was raised by Mr. Dr. Rajesh. So basically, the question which was raised wherein the resolution applicant was taken in a custody, a judicial custody. Some complaint must have been lodged against him. Some action was taken against him before the court of law. Now, this is what I must say as far as 32A is concerned, subsection 1 clause B. If now, in your case, even though the plan is not approved by the adjudicating authority, but suppose if the plan results in the change in the control or change in the management to a person to whom the relevant investigating authority has, on the basis of material in possession, reasons to believe that he had abetted or conspired for commission of an offense, and has submitted or filed a report or a complaint to the relevant authority. And that's why it is advisable in your case to go before the COC and to advise them that why that plan should not be considered for the time to come, or why the necessary alternative should be opted for, though it is not liquidation, but again coming up with a fresh EOI or anything other than that. Going further, provided that if the prosecution had been instituted during CIRP, now this is pertaining to the CD, company के बारे में बात हो रही है. If the prosecution had been instituted during the CIRP against the corporate debtor, it shall stand discharged from the date of approval of the plan, subject to the requirement of this subsection having been fulfilled. No action shall be taken against the property. Yes. Subsection 2 of section 32A, no action shall be taken against the property of the CD in relation to an
Salman,
offense committed. If there is any question, we can deliberate upon first. So subsection 2, we should deal with. No action shall be taken against the property of the CD in relation to an offense committed prior to the commencement of the CIRP, where such property is covered under the resolution plan approved by the adjudicating authority, which results in again the same thing, change in the control of the corporate debtor to a person, or sale of liquidated asset under the provision of chapter 3 or of part 2 of the code to a person who was not. Meaning thereby, as far as the property is concerned, we have seen
ఈ
this.
గేట్ ఎందుకు పక్కన ఇంకో గేట్ ఉంది.
So no action shall be taken against the property of the CD in relation to an offense committed prior to the commencement of the CIRP, where such property is covered under the plan approved by the adjudicating authority under 31, and that results to change in the control of the CD to a person, and the same facts will run. So in that case, what we have seen, that attachment of the property under Money Laundering Act, Enforcement Directorate, that things is being settled by 32A. That action cannot be taken against the property of the CD in relation to an offense committed prior to the CIRP, where the property is covered within the resolution plan approved by the adjudicating authority, and because of the approval of the resolution plan, that has resulted in change in the control of the CD to a person other than a promoter or in the management or the control of the corporate debtor, same parties. So if the company is being handed over to the same parties, in that case, the relaxation will not be permitted. For the purpose of this subsection, it is clarified that an action against the property of the CD in relation to an offense shall include the attachments or seizure or retention or confiscation of such property under such law as may be applicable to the corporate debtor. So such action will not be permitted if the resolution plan is covering that property and resolution plan is approved by the adjudicating authority, and because of the approval of the resolution plan, now the corporate debtor is not going to be handed over to the same old person. Nothing in this subsection shall be construed to bar an action. So this is making the things very clear that this privilege is only going to be availed by the corporate debtor and not the SBOD. Nothing in this subsection shall be construed to bar an action against the property of the person other than the corporate debtor or the person who had acquired the property through CIRP or liquidation process and fulfill the requirements specified in this section, against whom such an action may be taken under such law as may be applicable. So this is making the things again clear that this subsection shall not be construed to bar an action against the property of any person other than the CD or person who has acquired the property. Subject to the provision contained in subsection 1 and 2, notwithstanding the immunity given in the section, the CD and any person who may be required to provide assistance So even in spite of having this immunity, but the CD and the person who may be required to provide assistance under such law as may be applicable to the CD or the person shall extend all the assistance and cooperation to the authority investigating an offense committed prior to the CIRP. So this is 32A. I was of very clear opinion that you cannot discuss the subject without first referring these provisions of the code, which is having a very direct impact on the subject matter of discussion. So this is what the provisions of the code we dealt upon section 30, which is having the relevance with the subject of today's discussion, section 31, and very well subsection 4 of section 31. Section 32A, this is what we had discussed, and section 33 subsection 3, which talks about the contravention by the successful resolution applicant with regards to implementation of the plan, and leading to which the interest of the stakeholder, the interests are prejudicially affected because of such contravention, then in that case, the person whose interest is going to be impacted or adversely affected may move an application to the adjudicating authority for seeking an order of liquidation. And in given circumstances, if the adjudicating authority determined that the CD has contravened the provision of the plan, it shall pass an order for the liquidation. This is section 32. 33 subsection 3, yes. So now moving to the regulation side, that what are going to be the mandatory contents, what is the relevant of having those mandatory contents, what are the reasons leading to which the failure are being faced in implementation of the resolution plan, what are the aspects to be covered while adjudicating or while giving a note to any resolution plan by the COC. So we should take care of the regulation part. In case if you have some concern to discuss, please share. Yes.
Can I ask one question?
Yes, sir,
Which
please,
is
sir.
not related to the resolution plan. Is it regarding
Please.
PG to CD? Actually, this PG to CD, even if CARP is not initiated against the CD, can we proceed against PG?
Sir, may you please repeat your question?
Actually, CARP, what I can also say is that lender has not proceeded under CARP against the corporate debtor, but if the lender wants to go against PG, can it be done? I think there are some contrary.
Absolutely, yes, because see, there is no precondition that first you initiate an action against the corporate debtor, and then only in case of failed action or in case of non-recovery of the entire amount, you can proceed against. But make sure the guarantee should have been invoked and default should have been committed. I hope you are getting the answer.
Notice is to be given and then only. Yeah.
So first you need to.
Yesterday there was a case decided in the NCLT.
Sir, my point is,
NCLT
when
Kolkata.
you approach the adjudicating authority
Yeah.
against the personal guarantor, what you need to establish is the default. So being a lender, whether you will recover the amount first from the principal borrower or surety.
I want to
My
proceed against PG directly.
No, sir. I am very well getting your question that you want to proceed against the surety, personal guarantor. But here my question is, you being a secured lender in whose favor the guarantee was extended. My question is, you will recover the amount first. In case of default, you will recover the amount first from principal borrower or from the guarantor. The right now question is not pertaining to against whom you want to proceed. The question is pertaining to against whom you would like to first demand your overdue sum.
Some disconnection.
Your
Hello.
Yes. Sir, is I'm
Yes, sir.
audible?
Proceed, sir. Some disconnection.
My question
Yeah, just
is,
now it is audible.
yes, my question is,
Uh,
my question is, from whom you are going to recover first? Is it from the surety or is it from the principal borrower?
that is what I'm asking, sir. Can we directly go against PG without
Sir,
proceeding
no, 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 no,
from
no,
the
no. My
suit?
point
So we will raise the
first,
demand and he has not paid.
yes.
We will
So this
proceed
is
against
what my
corporate debtor upon his refund.
yes. So in case if the principal borrower commits a default, then you will invoke guarantee. In case if you invoke the guarantee, and
Yeah.
if the guarantor has committed a default, in that circumstances you can very well go against the guarantor without initiating any action against the corporate debtor. Hope I'm clear with my answer. So as far as the regulations are concerned, now first I would like to touch upon the issue in question or the question of law before the Honorable Supreme Court in Jet Airways. And that is in section 36. Yes. Now, when you see section 36B, RFRP, request for resolution plan, it is provided that the resolution professional shall within 5 days of the date of issue of the final list issue the information memorandum, evaluation metrics, and request for resolution plan to every resolution applicant in the final list. So this is post the procedure adopted for invitation of expression of interest. So based on Form G, you have submitted your expression of interest. Your name was there in the provisional list. Then objection was raised from the investors whose name was not there in the provisional list. And after that, when the final list is announced, it is required that the information memorandum, evaluation metrics, and the RFRP should be given to every resolution applicant in the final list. Request for resolution plan shall detail each step in the process, manner, and the purpose of interaction between the RP and the prospective resolution applicant, along with the corresponding timeline. Request for resolution plan shall allow prospective applicant a minimum 30 days to submit a plan. And this is very relevant. Very relevant. The request for resolution plan shall require, this is 4A. I'm talking about section 34B, subsection 4A. RFRP shall require the RA in case its plan is approved under subsection 4 of 30 to provide a performance security. And this was a matter of concern in Jet Airways. To provide a performance security within a time specified therein, and such performance security shall stand forfeited if the plan, if the resolution applicant of such plan, after its approval by the NCLT, fails to implement or contributes to the failure, fails to implement or contributes to the failure of the implementation of that plan in accordance with the terms of the plan and implementation schedule. This was the concern in the Jet Airways. It was 150 crores performance guarantee. The request for resolution plan shall require RA in case if the plan is approved under 4 of section 30 to provide a performance security within the time specified therein, and such performance security shall stand forfeited if the applicant if the resolution applicant of plan, after the approval by the adjudicating authority, fails to implement or contributes to the failure of the implementation of the plan in accordance with the terms of the plan and its implementation schedule. This is the concern, or this was the dispute. And that's why I highlighted upon. Otherwise, as far as the plan is concerned, Regulation 37 of Insolvency and Bankruptcy Application to this Corporate Insolvency Resolution Process Regulation 37. A resolution plan shall provide for the measures that may be necessary for insolvency resolution of the CD for maximization of the value of its asset, including but not limited to following: transfer of all or part of the assets of the CD to one or more persons. So I can propose a plan on this particular parameters, that the asset of the CD shall be transferred, whether in full or in part, to one or other person. Sell of all or part of the assets, whether subject to any security interest or not. So this is indicative of the fact that what all can be a modus of proposing a resolution plan, based on what parameter I can prepare my plan, or based out of what strategy I can propose a plan. That I can place a proposal that I'm going to transfer the whole or in part of the asset of the CD to one or more than one person, or I will sell all or part of the asset, whether subject to any security interest or not. This is very important aspect: restructuring of the corporate debtor by way of merger, amalgamation, and demerger. But it is important that it is required that a separate application to be moved for the same. Restructuring of the corporate debtor by the way of merger, amalgamation, or demerger. This can be a basis on which my plan stands or survives. The substantial acquisition of the share. This happens in listed companies. What happened either in the resolution plan, I'm canceling to all the share capital of the CD, or the plan must be having a provision wherein I'm going to acquire the shares of the corporate debtor, or it may carry a provision of delisting also. The substantial acquisition of the share of the corporate debtor, more merger or consolidation of the corporate debtor with one or more person. This can be provided or proposed on the basis of which you are proposing a plan. Cancellation or delisting of the shares of the corporate debtor if applicable. Satisfaction or modification of any security interest. This is also can be covered in the resolution plan. Either I will be making an upfront payment, the lender is accepting an haircut, and the security interest, or the property over which security interest is created, is now been satisfied, will be considered satisfied, or modification of any security interest. Curing or waiving of any breach of the terms of any debt due from a corporate debtor. Waiver I can expect from my lenders. Reduction in the amount payable to the creditor that amounts to modification of charge. Extension of the maturity date or change in the interest rate. This is what I can propose to my lenders, and this is what I can expect from my COC to allow. Extension of maturity date, change in the rate of interest, or other terms of a debt due from a corporate debtor. Amendment to the constitutional document, and one thing is very clear, that for such amendment the Companies Act mandatory prescribed that you need to take the approval from the shareholder. But when your plan is being approved by the COC, it will be presumed, it will be assumed, and it will be sufficient that no such further approval of the shareholder shall be required. This is what we used to see, that when a company is going concern, the certain power stays with the board and certain power stays with the shareholder. But when company goes into CIRP, the power of the board or the shareholders are being taken care of by, or rather calling board, but at least the power of the shareholders are being exercised by the COC in majority of the cases. We have seen section 28 of the code. Issuance of security of the corporate debtor for cash or property, or in exchange of the claim or interest. So this is also you can propose in your plan. Change in the portfolio or goods or services produced or rendered by the corporate debtor. So this also makes one thing very clear, that if a company is proposing a plan, for that a company is not required to be in the very same segment, and you can propose a plan in which you can change the entire horizon or entire scope of services which the corporate debtor is into. Change in the technology used by the CD, obtaining approval from the central and state government or other authorities, sale of one or more of the asset of the corporate debtor. Now, this is very important. Sale of one or more of the asset of the corporate debtor to one or more successful resolution applicant, submitting a plan for such asset and manner of dealing with the remaining asset. This is something which I face, or this is something which I feel. This is a very recent amendment of 16th of September 2022. But this can also be made possible through resolution plan from more than one resolution applicant. Sale of one or more asset of the corporate debtor to one or more successful resolution applicant who have submitted a plan for such asset. So asset wise also you can propose a resolution plan, and asset wise also a two separate successful resolution applicant can be identified. This is clause M. I'm reading for the sake of convenience. We are on regulation 37 and we are considering regulation 37. We are just taking care of what is there in clause M, introduced recently with effect from 16 September 2022. Sale of one or more of the asset of the CD to one or more successful resolution applicant, submitting resolution plan for such asset and manner of dealing with the remaining asset. This is something which can very well bring an amicable solution to a distressed corporate debtor. What's your say on this? I'm just questioning this thing before the one, in case if at any point in time you have invited plan on the basis of the assets.
He will also be in the from the final list of uh, selected resolution
Asset.
applicants. Must be.
Correct.
This how it can happen, sir? See, ultimately one resolution plan will be approved. Will it be? Will there be 2-3 plans approved when it is assets are sold in piecemeal basis?
And this is what clause M is talking about. So suppose
Yeah.
if a corporate debtor facing CIRP is under CIRP having more than one asset, and I think this is going to be very well implemented in the real estate CIRP, wherein more than one scheme are under challenge, where one of more than one scheme of the real estate or any of the commercial estates are facing the heat from its lender. In that circumstances, this can be very well implemented, and with that rationale itself, this is proposed or this is brought in. One or more asset of the CD to one or more successful applicant, submitting a plan and a manner of
That means
dealing with the remaining asset. Yes, sir.
RFRP must be clear on that, I think.
Absolutely, sir. Anything else? I'm just inviting your views on it, because this is not something a very or some extended deliberation has not been taken place on this aspect. Selling of the asset of CD to more than one successful applicant, inviting a resolution plan for on us on the basis of the asset, and also the manner in which the rest of the assets will be dealt with. Because this is how you can propose a plan, but make sure this should be the basis on which the plan is being requested for. So what you said is very
Actually,
much
this
taken into.
gives a lot of flexibility also, where a company may be having different locations, plants at different locations, maybe one in Punjab, one in Chennai, one somewhere else. And a person from Punjab may not be liking to go to Chennai, and the
Absolutely, sir.
Chennai person may not be liking to come to Punjab. So in such kind of situations, this will give a lot of flexibility in the resolution of the corporate debtor.
Absolutely,
And
to Raj.
of course, I think this is a very good provision, I believe. And
Absolutely, because I've
particularly
seen majority
in the
of the
case of
resolution
real estate
applicant.
assets also, as you mentioned, real estate assets, many companies have number of projects. One of the project may be doing good, another project may not be doing good. So
And
there could be
inviting
different.
and
take of
inviting
different.
project wise resolution plan that things makes, or that basically you can get you can say there is possibilities of getting the resolution early, at least
Early,
certain
and
areas.
also possibility of getting higher value. That is, which is the basic objective of IBC.
Touching upon regulation 38, which deals with the mandatory contents, and yes, one cannot forget that section 31, which talks about that adjudicating authorities horizon or scope get extended when they see the provision pertaining to effectiveness co-op implementation of the resolution plan. So as far as regulation 38 is concerned, and when it say mandatory content, meaning thereby you need to take care of every aspect, the amount payable under the plan to the OC. So again, I must say that though it is not falling within the jurisdiction, but yes, adjudicating authority will see whether it is complied with the requirement of section 30 subsection 2 or not. Qua the operational creditor shall be paid in priority over the financial creditor, and the dissenting financial creditor who have right to vote under subsection 2 of section 21 but did not vote in favor of the plan shall be paid in priority over the assenting financial creditor, those who have voted in favor of the plan. So this is very well falling within the ambit of the adjudicating authority to see whether it is in compliance with subsection 2 of section 30 or not. But apart from that, plan shall include a statement as to how it dealt with the interest of all the stakeholder, including financial and the operational creditor. So very much connected with section 30 subsection 2. As far as 1b is concerned, and that is regulation 38 1b, which talks about a plan shall include a statement giving details if the applicant or its related party has failed to implement or contributed to the failure of the implementation of the plan by the adjudicating authority at any time in the past. So now the successful resolution applicants of the Jet Airways will be having this issues, or they need to take care of this issue into consideration before they propose any resolution plan for any other distressed corporate debtor. Plan shall include a statement giving details if the applicant or any of its related parties has failed to implement or contributed to the failure of implementation of any other plan approved by the adjudicating authority at any time in the past. And here for this subclause 1b, or this is for sub-regulation 1b of regulation 38, there is no look back period. It is provided that at any time in the past, if I have been a resolution applicant or any of my related party been a resolution applicant who either failed to implement or has contributed to the failure of implementation, then in that circumstances, this should be included in my plan. So they will not be debarred, but they should make the things clear in the plan itself by including a statement giving a complete details about that plan. Resolution plan shall provide the term of the plan and its implementation schedule. Now, whether this can be subject to revision or not, this is something a point of, or this is very a subjective nature point, whether the COC has permitted such clause or such conditions in the plan or not. So, term of the plan and its implementation, because in JET, this is what we have seen, that it has been extended various time. The term of the plan and its implementation schedule, the management and control of the business of the corporate debtor during that term. So, who will be on the board? This is also you are required to make it clear. Adequate means for supervision of implementation. So, this is what we have seen, that in this particular regulation, there is no requirement, or there is no regulation or sub-regulation talking about having a mandatory monitoring committee or monitoring agency. This is what you need to propose in the plan. But now the discussion paper which is brought in by the IBBI for the sake of inviting comments in this regard, has made it clear that now it is it has to be there that within the framework of the regulation itself about the monitoring committee, that who will be the face of the monitoring committee upon the approval of plan. So resolution plan shall provide that the term of the plan, its implementation schedule, the management and control of the business of the CD during the term, and adequate means for supervising the implementation. Provide for the manner in which the proceedings in respect of avoidance transaction or fraudulent or wrongful trading will be pursued after the approval of the plan, and the manner in which the proceeds, if any, from such proceedings shall be distributed. This is something not so relevant for our session. Resolution plan shall demonstrate, this is important, how it is addressing the cause of default, how the plan is feasible and viable, how it has made a provision for its effective implementation. And this is something which is subject to the satisfaction of the adjudicating authority. Of course, after getting the approval from the COC, but this is where the adjudicating authority have its own ambit of review. Adjudicating authority has its own scope of review, that how it is covering, and this is what has provided that plan should demonstrate that how it has made a provision for its effective implementations. It has provision for approval required and timeline. And I must say, after the jet failures, or after the failure of the jet airways and liquidation thereof, this will be taken into utmost sincerity, or this will not be disregarded. This is going to be the topmost point of scrutiny, or topmost point of adjudication for the adjudicating authority, or topmost point of, you can say, review or consideration before approval of any plan, even by the adjudicating authority. Provision for effective implementation and provisions for getting the approval required and timeliness for the same. So I'm talking about those plans which are coming up with the condition precedent. The resolution applicant has the capability to implement the plan. The committee may consider the requirement of, now this is something which has gained some importance. The committee may consider the requirement of monitoring committee for the implementation of the plan, and after jet it is now gaining, or this is now going to gain a weightage. The committee may consider the requirement of a monitoring committee for implementation of the plan, where the committee considered that the monitoring committee for the implementation of the plan is required. So rather, if putting into the discretion of the committee, now it is going to be made mandatory. While approving the plan, decide to constitute the same with the resolution professional, or propose any other resolution professional or any other person as its member, provided where the resolution professional is proposed to be a part of the monitoring committee. The monthly fee payable to him shall not exceed the monthly fee received by him during CIRP. That is not so important, but yes, now it is not the COC's discretion. The committee may consider the requirement of monitoring committee for implementation. It's not may now. The committee consider that a monitoring committee for implementation of the plan is required, then it may, while approving the plan, decide to constitute the same. Now it is going to be a mandatory requirement, and this is what Supreme Court has made it very clear while passing an order in the matter of Jet Airways. Approval of the plans, Regulation 39. A prospective resolution applicant in the final list may submit a plan or plans prepared in accordance with the code and this regulation to the resolution professional within the given time with an affidavit that he is eligible. And this clause is very important. An undertaking by the prospective applicant that every information and record provided in connection with in the plan is true and correct, and discovery of any false information or record at any time will render the applicant ineligible to continue in the CIRP and forfeit any refundable deposit or attract penal action under the code. This is sub-regulation 6, which is talking about a provision in the plan which would otherwise require the consent of the member. And this is what I said, that when you are getting the blanket approval from the COC, you are not supposed to take care of. So this is notwithstanding anything provided any Companies Act or any other law for the timing in force applicable. A provision in the plan which would otherwise require the consent of the member or the partner of the CD, as the case may be, under the term of its constitutional document. तो आपने अगर LLP deed में कह रखा था that it requires the consent from the designated partner or the unanimous approval of the designated partner, yeah, in case the act or the constitutional document like article of association is of that view that for this it requires the approval from the shareholder special resolution, or if you are under the bondage of any SPA or SHAs or any joint venture agreement. But I said notwithstanding anything, a provision in the resolution plan which would otherwise require the consent of the members or the partner of the CD, as the case may be, under the term of constitutional document of the CD or shareholders agreement or joint venture agreement or other document of similar nature, shall take effect notwithstanding that consent has not been obtained. Because here it is the COC who need to approve it, and after that it is the adjudicating authority who need to see whether it is in accordance with section 30 subsection 2, or whether the plan is having the implementation or not. No proceeding shall be initiated against the IRP or the RP, as the case may be, for any action of the corporate debtor prior to the insolvency commencement date. So this is an immunity which is provided to IRP and RP for any act prior to CIRP. A business and operation of the CD after a plan is approved, adjudicating authority may make an application to adjudicating authority for an order seeking the assistance of the local district administration in implementation of the terms of the plan. This is relevant if I am a person who is in charge of the management as far as the resolution plan is concerned, then I may make an application to the adjudicating authority. It's me and not the RP. It's me being a successful resolution applicant and not an RP who need to move an application to the adjudicating authority for seeking an order, purpose of seeking an assistance of the local district administration in implementation of the term of the plan. A creditor who is aggrieved by non-implementation of the plan approved under subsection 1 of 31 may apply to the adjudicating authority for the direction. And this is what we have seen in section 33, subsection 3 also, that if I'm the creditor or I'm any stakeholder who feel aggrieved because of the non-implementation or breach of the resolution plan, which was approved under subsection 1 of 31, then I may move an application before the adjudicating authority, and adjudicating authority may pass an order even for a liquidation. And that is what we have seen under section 33, subsection 3. Yes, your views are invited in case if you have anything to deliberate or discuss or to raise a concern about. Before we look into the jet part, or before we look into the discussion paper brought in by the IBBI. There's one more thing to share, and there is a general circular of March 2020, and this is from the viewpoint of the compliances qua the Companies Act. It is General Circular number 8 of 2020, dated 6th of March 2020 of the Ministry of Corporate Affairs, which I would like to share, which is having some relevance for the acting IRPs and RPs. I'm sharing the screen. Is it visible?
Yes, visible.
Now, this is what a very old circular, I must say, but a change which I have seen or what I have witnessed, that is what I would like to highlight upon. But this is with regards to filing of forms in MCA registry by the IRP and RP or the liquidator appointed under the IBC. It is provided that once the company goes into CIRP, though it is not relevant for this moment, because we are right now dealing into the aspect of the approved plan and not the admitted CIRP. But IRP, RP or liquidator would have to first file the NCLT order approving him as the IRP, RP or liquidator in Form INC 28 by selecting the drop down box in field 5A3 by selecting the appropriate selection. After filing the said form, IRP, RP or liquidator while affixing his DSC shall choose his designation as a CEO in the declaration box for the purpose of filing only and choose other form. So, meaning thereby now all the compliances will be undertaken from the digital signature of the IRP, RP or the liquidator as the case. Maybe this is something which is known. This is important. In one of the case wherein I was representing a successful auction purchaser, he, in spite of acquiring the corporate debtor in sell or during the by the way of sell as a going concern, being a listed entity, there are certain overdue compliances which he was supposed to take care of. But the issue which he was facing pertaining to the status of the corporate debtor in the MCA portal, which was showing as under liquidation. Since the corporate debtor was ordered for liquidation and thereafter the company was purchased by him as in sell as a going concern, but the status was not being approved. So we requested registrar of companies for multiple times, and he indicated about the circular that how this power has been now shifted to the ministry, to the center, and not it is now a decentralized. So it is no more a decentralized one, and you need to approach the ministry rather approaching the registrar. Of course, you need to report to the registrar by filing this form INC 28 attaching the order of the adjudicating authority, but everything will be pursued from the IBBI and things will be pursued from the ministry and not from the ROC. This is what I would like to indicate out of this circular. The master data for change in the status of the company from active inactive to CIRP or liquidation or from liquidation to active shall be effected on the basis of formal change request form. This is not within your hands. Submitted by IBBI to MCA. Since this function has been centralized, the ROC shall not raise or forward any change request form either to e-governance cell or to service provider for the above mentioned purpose. Meaning thereby, I've seen many of the RPs are approaching, or the advisor to the RPs are approaching, or the advocates are approaching the office of the registrar for pursuing the change in the status of the company. But it is the obligation on the part of the concerned IRP, RP, or the liquidator to intimate the fact about the approval of the plan or about selling of the company as a going concern or about the successful purchaser. You need to intimate the fact to the IBBI, and it is the formal change request form which will be submitted by IBBI to ministry. And this is very clearly stated in the circular that this function has been centralized and ROC shall not be in a position to raise or forward any CRF, that is change request form, to either MC or to the service provider. This is what I would like to highlight upon. There are certain more concern about the filing of overdue returns. I have acquired a corporate debtor. That corporate debtor was acquired by me through a resolution plan. But that corporate debtor has never submitted any financial statement, which otherwise is mandatorily required to be submitted every year to the registrar. So, leaving that phase behind, the IRP or the RP has to take up the charge from the date of his appointment, and they should be responsible, clearly stated, shall be responsible for filing of all the forms in MCA portal and sign the form in the capacity of CEO in order to meet the filing protocol in the existing form architecture. However, this shall no way affect his legal status as an IRP, RP, or liquidator. All filing of form, including AOC4, MGT7, shall be filed through e-form GNL2 by the way of attachment. So, anyways, not relevant at this moment, but I would like to say the only thing which was relevant for discussion is pertaining to when I say that my plan is approved but not being implemented. My plan is being approved, but I am not in a position to report the same. Or my plan is approved, but I am not in a position to bring the face on the system. Or I am not in a position to change the signatory on the MCA portal because of this technical difficulty. So the status will not be altered by pursuing the office of the registrar. And as it is clearly mentioned that this procedure has been now been centralized. And it is the IBBI to whom you need to the report, and after reporting to the IBBI, it is the IBBI who will forward its change request form to the Ministry of Corporate Affairs, and it is the Ministry of Corporate Affairs who will facilitate the change in the status of the corporate debtor from CIRP to active or from liquidation to active, and not the ROC. I've seen the struggle or the immense struggle by approaching the registrar is not bringing any solution. And the only reason of not getting any solution is the registrar are the ROC at its a decentralized level are not empowered to make any or are not in a position to bring any change in the status of the corporate debtor. Let's have before us a recent discussion paper, though it is only a discussion paper, but that indicates the intent of the Supreme Court, which has now been reflected by the IBBI through a discussion paper. Though the comment was invited up till first week of December, which is now over, and we are expecting some amendment to be brought in the regulation and the provisions of the law.
So one of the challenges that I feel in the process of resolution plan is the delay in approval of resolution plans by the adjudicating authority.
And that's why when we see the Jet Airways order of 7th November 2024, the things are very clearly stated that the extension and exclusions applications are not going to be considered in every cases, because see, this is the leading reason every extension and every exclusion are attributable to this extension in the CIRP process. So I believe that this timeliness of 330 days need to be strictly followed,
Yes.
because every alternative applicant is coming up with this case as being a special case, and why that extension beyond 330 days should be allowed. So timeliness are being or the application
Because
for
the
seeking
extension
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 are
is one aspect. So once the plan is approved by the COC and it is submitted to the adjudicating authority. Now, I've seen a couple of cases where the resolution plan has taken maybe 5 years. The amount offered by the SRA is say 100 crore rupees, and the plan is not approved for 5 years. Maybe in between the COVID had come and there were other factors, the workload at NCLT, paucity of time, and all those things happening. Now, this leads to the result that the stakeholders are losing interest in that 100 crore rupees. The valuation is increasing. In both ways, it's going against the interest of the stakeholders. And no one except the SRA standing to gain. And then sometimes SRA also loses because of the change in the dynamics, market dynamics. So all these things are creating a lot of problem, and I believe if the delays are happening, the real objective of IBC is getting diluted.
is getting impacted.
Somewhere or the other. So then there is no provision for revaluation of assets also. For example, in a case that I was discussing that the ED has come in, the plan is already there before NCLT for about 5 years. So now in that case also, there is a lot of problem with respect to the amount which was agreed to be paid. The stakeholders didn't get that amount. They have lost the interest, and now they are maybe considering as the SRA, this RA number two, who was the second highest. But then the revaluation of assets, whether it should go to revaluation of assets at this stage, if the plan is taken back and suppose new AOI is issued, then again the clock will start ticking. So it will take long time. So all these things are uh, the irritants in this entire process of.
Sir, I believe the cause of this issue is the timeliness which is provided is considered as a directory and not mandatory. Say,
Absolutely.
for example, it is provided that 15 days prior to the expiry of 180th day, the
Mhm.
plan which is approved by COC is required to be placed before the adjudicating authority. In that circumstances, why it is not being mandatory for the investors to check this timeliness while proposing a plan, and why it is not making mandatory for the adjudicating authority also to see the timeliness provided for those 15 days to approve or to reject the plan.
Actually, that also the adjudicating authority is facing a lot of challenges because these suspended directors, they would come up with one or the other innovative application, that has a direct impact on the resolution plan, directly, indirectly, and these kind of things also
And this is
add
what
a lot
I'm
of
telling,
delay.
sir. This is what I'm telling, that in majority of the cases, the timeliness which is prescribed initially in the code has now been made as a directory everywhere. So now the approach is very casual for the litigant also. Seeking an extension after the expiry is also being entertained
Mhm.
in the guise of that this period was excluded, and that's why the extension at this moment should be allowed. So in every now and then case, the extension applications are being entertained considering the objective of the code, but because of taking the benefit of the objective of the code, ultimately the stakeholder interest is being implemented at this stage, and later on at the stage when the implementation is that challenge is being faced during implementation of the plan. You are very correct. And that's why in this judgment I have seen, the Supreme Court has made it very clear in the Jet Airways case, all those aspect has been made very clear that with regards to extension, with regards to monitoring committee, with regards to the members of the adjudicator, this NCLTs, this everything is very well covered in the order of this Honorable Supreme Court dated 7th of November 2024. I would like to first place before you the discussion paper which I was intending to place before, because this is nothing an outcome of that Supreme Court judgment. It is very well available on the IBBI portal also, dated 19th November 2024. Hope my screen is visible. So this is the issue. The discussion paper deals with the following issue faced in implementation of the plan under the IBC. The Honorable Supreme Court, in its judgment dated 7 November 24 in the matter of State Bank of India and others versus Consortium of Murari Lal Jalan and Mr. Florian Fritzrich, emphasized that the need for statutory recognition. So this is what I'm talking about, the Jet Airways case. This is the Consortium of Murari Lal Jalan and Florian Fresh in the case of Jet Airways, emphasized the need for statutory recognition of the monitoring committee. Up till this moment, we have seen it is the prerogative or it is a discretionary power given to the COC to decide for the need of having a monitoring committee. Emphasized the need for statutory recognition of the monitoring committee and made several key recommendations regarding their constitution and functioning. The court observed 181 para. As regard the implementation of the approved plan, it is suggested that IBC statutorily provide for constitution of monitoring committee. Statutorily provide. So it is required to be brought in within the statute itself once the plan has been approved. As on date, the thing is, as far as the implementation is concerned, it is the plan which is being placed before the COC in a manner as if the successful resolution is proposing that who will be the face in the monitoring committee, or else the COC is deciding about the monitoring agency or committee. But this is what the Supreme Court has stated, that it is suggested that the code statutorily provide for the constitution of the monitoring committee once the plan has been approved. Presently, such a provision is absent in the code, and it is the adjudicating authority that order for constitution of the monitoring committee to ensure smooth implementation of plans. So this is what we were discussing while taking care of the regulation side. The COC must be empowered to constitute monitoring committee, which may by default include RP. There we have stated that RP or any other insolvency professional, which may by default include RP and also include the nominee from COC and resolution applicant respectively. So emphasis is on RP who was taking care of the CIRP process, also the nominee of the COC and the resolution applicant. Such a monitoring committee would be entrusted with power of monitoring supervision of the plan till the expiry of the term of the plan. The committee shall also be required to ensure all the statutory compliances during implementation of the plan, along with updating adjudicating authority, financial and other creditors about the status of implementation of the plan on a quarterly basis. This is what we have seen in the merger amalgamation matter, because that scheme of amalgamation and merger, till it's get completed or till it's get implemented, we are bound to report to the registrar in a very similar lines, in a very similar fashion. This is what been proposed through discussion paper. The committee shall be required to ensure all the compliances during the implementation, though it is the responsibility on the part of the RA to undertake it, but it is a duty on the part of the committee to make sure about the compliances during the course of implementation and to update the fact about the adjudicating authority to the financial and other creditor about the status of implementation of the plan on quarterly basis. Regulation 38 of the CIRP regulation was amended on 15 Feb 23 to empower COC, and this is what we were dealing into, to empower COC to consider the requirement of monitoring committee. So this is the law right now before us. This is the regulation right now before us, and above stated is the thing which is proposed. At present, what is the case is it's a COC to consider the requirement of a committee for implementation of plan. Whereas such a committee is considered necessary, the COC may, while approving a plan, decide to constitute it with the resolution professional or propose any other IP or other person as its member. The regulation also stipulate that where the resolution professional is proposed to be a part of the monitoring committee, their monthly fee shall. So this is what the provision, or this is what the regulation at this moment, but this is what has been proposed, that COC should be empowered to constitute the monitoring committee, which may by default include RP, include nominee of COC, include resolution applicant also. And this committee would be entrusted with the power of monitoring, supervising the implementation of the plan till the expiry of the term of the plan. And this committee shall statutorily required to intimate the authorities, that is adjudicating authority, to the financial creditor and other creditor about the status of implementation on quarterly basis. This is the proposal. In light of the observation made by Honorable Supreme Court in the aforesaid judgment, proposed to strengthen the regulatory framework governing monetary committee under the code, while current framework under regulation 38 provides certain basic recognition to monitoring committee, the proposed amendment aim to make their constitution mandatory for implementation of the resolution plan. Since COC is vested with the commercial wisdom and is primary decision-making body during CIRP, the proposed framework empowers COC to take the final decision on the constitution, composition, and functioning period for monitoring committee as a part of the resolution plan. The COC shall retain flexibility to decide for constitution of the monitoring committee with lesser period if the resolution plan provide for substantial implementation during the tenure with recorded reasons. This is what the Supreme Court has stated, and this is what the rationale of the Supreme Court suggestion. The monitoring committee shall consist of the member who have a direct stake in the implementation of plan. Committee shall be chaired by either the RP who handled the CIRP or other IP as proposed by COC. To ensure balanced representation of interest, committee shall include nominee from COC and equal number of the member of the nominee from successful resolution applicant. This composition structure ensure that both the creditor's interest and implementation capability of the RA are adequately represented in the monitoring process. Yes, sir. The framework also provides flexibility to exclude the existing member in case of changes or include additional person to be deemed appropriate by the committee. To maintain operational efficiency and accountability, it has been provided that the successful resolution applicant shall bear the expenses of monitoring committee while retaining the existing provision that IP monthly fees is capped at the amount received by the RP during CIRP period. Lastly, the monitoring committee is empowered with comprehensive supervision and monitoring function, including oversight of the plan, its implementation, ensure statutory compliance, facilitating smooth transfer of the assets and control of the RA to the RA. To ensure transparency and accountability, the committee shall submit quarterly progress report to the AA and board regarding implementation status. The committee shall continue to function until the completion of implementation, with clear provision for seeking appropriate direction from the adjudicating authority in case where the implementation is not in accordance with the terms and conditions of the plan. So this is the intent of the Honorable Apex Court, that how the implementation issues can be addressed. Yes, your views on the same.
The powers and the responsibilities of these monitoring committees are not properly covered in this discussion paper, I think.
Absolutely, Ahmed. That is what we can expect from the government now, that when they come up with this particular, the outcome of discussion paper is going to be there in the court very soon. And when they will come up with, again, it is not only confined to the monitoring committee, but I must say this is also required for the COC also. Let's see how favorably it will work. But I must say that the root cause, as we discussed before the discussion of the discussion paper, is the extended timeliness. And not only the extended timeliness till its approval by the adjudicating authority, but even thereafter. During the course of implementation, when the implementations are being challenged, the adjudicating authorities are the investors, the successful resolution applicant are still approaching the adjudicating authority for claiming such extension. So because of that, see, when things are made a time bound by the code, things are very strict in nature when you see the code. So when a layman read the code, the layman has to bear the things in mind that within this time I have to do this, or within this time this things are required to be completed or complied. But when a person, with the same person, will see how the things are being implemented, the flexibility is provided by the adjudicating authority, who is one of the major stakeholder for any successful resolution plan or for the successful implementation of the plan, like a RP or like COC or like a SRA. The adjudicating authority is also contributing to the success or to the challenges which are being faced by the successful resolution applicant or the failure of the resolution applicant to implement its plan.
The time that is lost between approval by COC and approval by adjudicating authority, this time, several plans, several cases, we are seeing that these cases are, means the SRA certainly means because of the lapse of the time, this change in the situation, the plan itself become, means they are no more interested. but
Absolutely.
they are mandatorily required to follow the timeline that are given to them as per the plan.
Hmm.
So there is no mandatory requirement for adjudicating authority due to infrastructure issues or any reason. But that time, what is lost is not means where that time is gone.
Correct.
That there is no solution, there is no discussion on that. Maybe there are discussions, but there is no solution to the time which is lost between filing of an application and admission of CIRP order. That time also there is no solution, and this there is no solution between approval of COC and approval of this adjudicating authority. The time lost in that.
I understand your point. And this is what I must say, that the topic is for the sake of discussion. But when we ourselves sits in the chair of the adjudicating authority, or when we function as an IRP, or when we function as an RP, or when we function as a successful resolution applicant, we feel that there are the practical difficulties, and that practical difficulties are somewhere which are not matching up with the expectations of the code, and that practical difficulties are not being addressed by any of the functionaries, not even by the adjudicating authority. But right now we are discussing this point just because of what we have seen as a downfall of the Jet Airways. So from that particular order, the things are very much, the discussion paper was proposed thereafter. So it was the 7th November 24 order, and the discussion paper was set forth thereafter. So everything is now coming because of the one unsuccessful resolution plan. Otherwise, day in, day out, there are many private limited companies, or there are several closely held public limited companies with a very limited stakeholder, or with a very limited beneficiaries, but they are facing the same nature of difficulty what a stakeholder of the Jet Airways have faced. But let's have a look on that order. As I said, that I will be taking care of that aspect at the end, which has generated this agenda for today's session, or which has generated that particular IBBI's proposal for having a discussion paper. I'm sharing the screen with you again. Would like to cover it up in a very time effective manner. So it was 7 November when the Supreme Court, in its judgment in SBI and others versus consortium of Murari Lal Jalan, have directed liquidation of the Jet Airways, bringing an end to the 5-year-old saga of efforts to review. So this is something which I must say that this is the background of the case, that this was approved in the year 2019. It was the jet which was admitted to CIRP by an order of the NCLT Mumbai bench on June 20th, 19. Over the next 3 years, several issues of its implementation come to test, and then nascent insolvency law framework, including a cross-border insolvency protocol between jet resolution professional and the administrator of the jet's liquidation proceeding in Netherlands. 22nd June 21, the NCLT approved the plan submitted by Jalan, the successful resolution applicant, following approval of the SSRA's resolution plan by Committee of Creditor. However, this did not bring an end to the jet insolvencies woes, as various challenges arose with the plan's implementation. SRA approached NCLT and the NCLAT for seeking extension of the timeliness and other directions on multiple occasions, which were granted by the NCLT and NCLAT from time to time. But in this recent judgment, the court set aside one such judgment of NCLAT and invoke its inherent power under Article 142 of the Constitution of India to order that JET be liquidated. The court judgment is significant as it underscores the importance of implementation of the plan with agreed upon timeliness, identifies certain gaps and shortcomings in IBC. As far as implementation of plan is concerned, this note analysis the court's judgment to discuss its implication for the implementation of plan, as well as specific challenges in context of the insolvency in airline industries. So as far as the background is concerned, Under the terms of resolution plan, the Jalan SRA was required to fulfill certain condition precedent prior to making the first tranche of 350 crores under the plan. The condition precedent included obtaining various licenses and approvals to operate an airline, such as validation of the air operation certificate, that is what has stated as AOC in the order, by Directorate General of Civil Aviation, obtaining slot allotment approval and the air traffic clearance. This were the condition precedent in the plan. The CP were required to be fulfilled, the condition precedent was required to be fulfilled within 90 days of the NCLT's approval, which further got extended, with the SRA being permitted to seek additional extension of time up to maximum 180 days or total of 270 days from the date of approval of the plan. In accordance with the request for resolution plan, the SRA had also furnished a performance bank guarantee of 150 crore, which was to be returned to it within 7 business days of completion of the plan. The request for resolution plan provided that performance bank guarantee could be invoked under certain condition, including if the SRA failed to implement the plan in accordance with the term. After obtaining several extensions for implementation of the plan, SRS submitted to NCLT that condition precedent had been fulfilled on May 25th, 2022, and sought exclusion of certain time period in determining the date by which the first tranche payment need to be made. NCLT agreed with SRA that condition precedent had been completed and granted it additional time to infuse the first tranche payment, but that was challenged before the NCLAT. The lender appealed before the order of NCLT before NCLAT, claiming inter alia that certain condition precedent had not been satisfied and submitted an affidavit. The lender's affidavit provided that the lender would withdraw their appeal and not press their claim regarding extension of the timeliness if SRA were to deposit the first tranche of 350 crore by August 31st, 2023, and otherwise scrupulously comply with the terms of the plan. In response to the lender affidavit, SRA filed an application with the NCLAT seeking direction to able to adjust performance bank guarantee against first tranche payment with NCLT as allowed. Now, this is a dispute which has started. Supreme Court, prior to passing an order on November 2024, 7 November order, Supreme Court on 18th Jan 24 has made it clear a year back. The order of NCLT and NCLAT were appealed to the Supreme Court, which in its judgment dated 18th Jan held that the performance bank guarantee could not be adjusted against the first tranche payment and directed SRA to infuse balance 150 crore of first tranche payment by January 31st. However, instead of making the payment of the first tranche in full within the timeline as stipulated by the court, the SRA deposited 2 billion 200 CR and sought to adjust performance bank guarantee against the remaining portion of first tranche payment. So this is something which Supreme Court has dealt with. On 18th Jan 24, Supreme Court has made it clear that PBG should not be adjusted. Performance bank guarantee should not be adjusted against the first tranche payment and has directed SRA to infuse the balance 150 CR of first tranche payment by 31st Jan. But instead of making payment of first tranche in full within the given timeline as up to 31st Jan, stipulated by the court, the SRA deposited 200 crores and sought to adjust the performance bank guarantee against the remaining portion. Well, and lenders moved to the NCLAT with respect to the inordinate delay in execution of the plan and SRA attempt to adjust the performance bank guarantee against the first tranche. NCLAT has allowed the adjustment and refused to accept the lender contention that resolution plan has failed. Aggrieved by the decision of the NCLAT, the lender moved to the Supreme Court, which ordered the jet to be taken into liquidation. This is the judgment. The Supreme Court has held that the NCLAT order allowing adjustment of performance bank guarantee towards first tranche payment was contrary to the court order, the terms of the request for resolution plan, the resolution plan, and settled law. So this is not only contrary to the Supreme Court's own order, but also against the terms for request for resolution plan and the resolution plan and the settled law. In doing so, the court rejected the SRA's contention that condition that performance bank guarantee could not be adjusted was only stated in the lender's affidavit but not in the plan. So this is what the say of the resolution applicant was, that this was not a condition in the plan, but it was only stated in the lender's affidavit. The court also cited Regulation 36B4A, which we have seen, which is stated that the successful resolution applicant would be required to provide performance security, which would be forfeited if the applicant fails to implement or contribute to the failure of the plan in accordance with the terms of the plan and its implementation. The language made it very clear that the performance security would have to be kept alive until the implementation of the plan and could not be adjusted or encased prior to it. And that is what we call it performance guarantee. It is settled law. There is no scope for modification or withdrawal of the plan following its approval by adjudicating authority, and SRA was required to implement the plan strictly in accordance with the terms. SRA's failure to deposit first tranche payment in full amount to a non-implementation of the plan. The court pointed out that the failure and resulting the contravention of various other terms of the plan, such as non-payment of CIRP cost, workmen and employees dues. SRA had already granted several extensions for implementing the plan and undisputedly failed to implement the plan, which one of the key objective of the code is revival of the debtor. This objective had to be balanced with efficiency and protecting the interest of all the stakeholders. Could observe that in scenarios such as the present, timely liquidation is indeed preferred over the endless resolution, and this is what we have seen. While invoking its inherent power under 142 of the Constitution, directed jet liquidation, court noted that it was being mindful of its recent judgment in the matter of Glass Trust Company, that is in Byju's, where it held that the court must exercise caution while interfering with the procedure prescribed under the IBC, and any deviation must be justified. However, in the case, the court held that extraordinary circumstances warranted the court to use its inherent power under Article 142 of the Constitution. This is the eye opener case. We can see this. So this is where I can mention that this was the ultimate outcome, and this is what the conclusion is. The jet implementation, impending liquidation may be a disappointing add to a flagship airline. The court judgment presented the only viable solution and served to underscore the importance of timely implementation of the plan. Going forward, the NCLTs and NCLTs are likely to pay more attention to the steps for implementation of plan and more cautious while granting extension of the time. It also remains to be seen if central government and IBBI take on board the court's suggestion of developing an enforceable code of conduct for COC, not only monitoring committee. For resolution applicant, one of the key takeaways that need to ensure that the plan includes realistic timeliness and steps for implementation and does not contain ambiguous language that is open to interpretation. So I would like to say that this is absolutely an eye opener. The reason is here we have seen that implementation was being delayed, extension was being sought. The workman issues pertaining to the provident fund and gratuity was also a point of deliberation, and that was one of the reason that implementation has been impacted while getting an order from the Supreme Court that how they need to bring in the resolution amount of first tranche, within what timeliness they need to bring in the resolution amount. The performance security should not be adjusted against the resolution amount which is directed to be deposited or paid to the lender. They have mistaken by bringing the same amount which they have brought in as a performance security as an amount towards the first tranche, and it was finally decided by the Supreme Court that no repeated extension, no further delay in implementation and liquidation. that is the only recourse for rehabilitation or for bringing the best which is pending out of, or best which is still live or alive out of the jet aircrafts. So I mean to say that this is what the suggestion of the Supreme Court is, that the applicant should remain very much, you can say they need to be very practically evaluating their plan, and they see the things from the practical viewpoint, that what exactly the minimum timeline is required for its effective implementation. So in that circumstances, I must say that what I believe is the request for resolution plan should be, is going to be extended if any further suggestions are being invited by the IBBI, or if some amendments are brought in by the insolvency and bankruptcy board. But request for resolution plan will be more extensive now. The resolution plan will get more judicial scrutiny after getting its approved from the COC. The monitoring committee will be having the further more members. The scope or the role of the monitoring committee will be extended. Implementation in a phased manner and its reporting will be made mandatory. Till the application gets fully approved by the adjudicating authority, no application will be further permitted for any modifications or any for any amendments thereat. So I believe that some changes are anticipated, but some of the challenges which we discussed about, which are going or which are being faced by the RPs, or which are being faced by the constituted COC, or which are being faced by the successful resolution applicant, is not coming to an end. That is going to be a way forward. But I believe that extension will not be allowed, or exclusion application will not be taken in a casual manner. That is going to be disposed of in a very selective basis, and no extension would be granted in every cases mentioning about this being a special case. I'll invite in case if you have something to say in this regard. Difficulties will remain to survive even after the proposed amendment, or even after strengthening the monetary committees and its role in implementation. But I believe that the root cause of the delay in implementation is required to be targeted. An early disposal of several applications is going to be an aim of the adjudicating authority. Much of the delay is being caused taking care of the individual concern of non-admission of the claim, or partly admission of the claim, or rejection of the claim. Now, these applications are not something which is in the best interest of the corporate debtor and its stakeholder as a whole. Delay in submission of the claim. Now, there is no point of coming late when already the advertisement is there. You have to submit your claim within 14 days. You have to submit your claim within the extended period of 90 days. And you are coming up with a claim belatedly and now disputing that why your claim should be allowed or why your claim should not be allowed. Now, this consume a very precious time of the adjudicating authority, which otherwise should be given for giving a thought on the viability of the plan or implementation of the plan.
So, may I raise one question?
Yes, sir.
Coming to subsection 5 of section 30.
Yes, sir.
So, where we were discussing that this provision has not been challenged. So, I'm just wondering that the decision of COC is primarily an administrative decision which is based on the commercial wisdom of COC. So, whether the principles of natural justice, say for example, a person cannot be judge of its own
case.
So, whether this would be applicable to the administrative decision of COC?
And this is what being done. This is what is the practice.
Absolutely, because it's the administrative decision. This is not a judicial decision, because this is only based on the commercial wisdom of COC.
And I truly believe when a person is judging its own case, the ultimate end is very bad. Now, in this case, this is what I pointed out initially, that my proposal for my plan and my evaluation about my own plan or my node for my own plan, and my voting stake is enough for me to block any other resolution applicant to get its plan approved, my say on my plan, and ultimately I am the COC.
And suppose I am the only creditor in the COC.
This is what I said, and I am the COC.
And I am the only creditor in COC, and I am 100%, and I want to give my own resolution plan.
Ultimately,
So-
beneficiary and the loser will be the one. Then I must say that these are the certain provisions of the law which required an immediate attention.
No, I'm just trying to understand whether this kind of provision would be amenable to the writ jurisdiction.
Whether or not, but at least adjudicating authority should be cautious enough to see such plan when this plan are being approved by the COC and forth before their approval. And absolutely it require a judicial lens to review the actual commercial viability of the plan, which is something time and again being avoided in name of its COC's commercial wisdom.
So even NCLT cannot review the commercial wisdom of COC as far
Absolutely.
as the law that
But what I
exists as a
believe
law.
is it requires an independent lens who review the plan in given circumstances, which is what I narrated before this forum.
I think when we are going for public this publication of this Form G and all, so everyone is there. Everyone is free to file the plan, and with the given plan, if NCLT finds that a plan which was a better plan has been rejected by the financial creditor who was part of the COC, and his own plan has been admitted, then there is a question of interference. If the plan of the financial creditor itself is very good, means very good in the sense that is the best plan among the available, then where is the question of judicial intervention? Why
Let's
there is a
this
need of judicial intervention?
giving this remark of very good or excellent, let this remark should come from the independent member of the COC and not from the one who is proposing the plan, is the limited concern which we discussed. Our moot point is not that whether the member of the COC can propose a plan or not, or whether the plan of the member of the COC get a weightage or not. Our point of discussion at this moment is a person evaluating a plan is the one who proposed this plan, and the one who is proposing a plan, evaluating the plan, being a member of the COC, holding that much percentage of voting share that he can be a roadblocker for the other resolution applicant to get their plan approved. So this is just a point of discussion, sir. It may happen that his plan is not viable. Here you are taking one possibility or one permutation or combination, that is, this is the only one best plan amongst all, but this may be the other, or this can be other side also, or the case may be reverse also. But in that circumstances, just because of I being a member of the COC, holding this much percentage of the stake, evaluating my own plan, promoting my own plan, getting my own plan approved, and the adjudicating authority is giving a note to it.
No, what I mentioned is if there is a chance of bias, if there is any bias, apparently, then only there should be any interference. Otherwise, there should not be any interference.
But then also there is no interference because of subsection 5 of section 30. He is only coming up with the fact that I, being a member of the COC, am all permitted to cast my vote on my plan. So, anyways,
No, but if
this is subject matter
this
of
is
the
a subjective, this is a subjective matter. If the
absolutely.
other party who is unsuccessful resolution applicant can show that my plan is 100 rupees and his plan is 70 rupees, still he is approving his own plan, then there is a question of interference. Otherwise, if the plan is 100 rupees and 105 rupees, then why there is a interference? There is no need as such of the interference. Otherwise, also we are facing so much of delays. If adjudicating authority enters into the this particular era, this particular domain of looking into the commercial wisdom, then means the delay कुछ हो ही नहीं सकता. Means where it will go, nobody knows.
Right, sir.
Sir, I have a question.
Yes, sir.
Suppose 6 plans are there and 4 plans are very bad. So they can be rejected in piecemeal by COC?
Your question is there are 6 plans.
And
Out of
4
6,
plans are not up to the mark. So they can reject outright before deciding the final plan.
no, there is nothing like final plan. It is basically the procedure which states that I, being an RP, will see whether plan meet the requirement of the provision of the law or not, like what we have seen section 30, subsection 2, right? And thereafter, all the plans are required to be placed before the COC. Outrightly, nothing gets rejected unless it is individually voted upon.
And evaluation matrix is also to be applied.
Correct. I'll invite the questions in case if you have any, otherwise we can formally bring an end to the session.
So, sir, so finally, while rejecting other plans, one has to be approved before finalizing the. And what shall
Come
be
again,
the
sir.
language? What shall be the language to be returned to rejected plans? RP should write to the
It's
PRA.
always a voting percentage which speaks by itself. It is provided within the law that it requires the approval from the COC with 66% voting share. Now, suppose if the voting percentage is not enough or you are not getting a sufficient number of votes in favor of your plan, then this voting percentage states by itself that why the plan has not been approved by the COC, and very well it is a subject matter of deliberation within the COC while considering and taking care of each and every plan. So it's always a discussion which take place first. As said, evaluation metrics will be the one which evaluate the plan or which separate the one plan from other. And ultimately, post deliberation discussion, it is always the voting percentage of the COC which demonstrate or which indicate the which plan has got the approval or why not. But there is no such requirement to give a comment over that why this plan is not being accepted and the rationale behind the same.
Thank you, sir. Thank you. Thank you.
And the difficulty would arise only if 2 plans have the identical offer amount. Once one plan is priced higher, so it will rank number 1.
But opposite was the case in case of SR, wherein Ruya family has proposed an amount beyond what was proposed by the ArcelorMittal. So it's not always the amount or
Yes,
it's
of
not
course.
always the value which you are offering, but the other parameters also make some point of difference between the two resolution
Yes,
applicants.
of course. Thank you very much. It was a very well structured
Thank you very much, sir. Thanks for
program.
actively participating throughout this session.
Thank you, sir. Thank you.
Thank you very much. Thank you to the Institute of Company Secretaries of India for giving an opportunity to have an interaction with all the learned practicing insolvency professionals, and would like to be a part of such forums as a speaker or as a listener. Thank you very much.
Thank you very much, sir,
Thank you,
for
ma'am.
such a nice session. Thank you very much, all the participants for actively participating. And sir, please, you are requested to share if you have any material with you.
Certainly. Thank you very much.
Ma'am, when can we expect the certificates for this?
On Monday.
On Monday. Okay, ma'am. Okay. Thank you, ma'am. Thank you very much.